Good morning, everyone. Welcome to our first seminar, our first webinar in our three-part series on justice in the Southwest. We want to especially thank the Academy for Justice at Arizona State University for joining with us and helping us put this on. My name is Steve Handelman. I'm the director of the Center on Media, Crime, and Justice at John Jay College. And I just want to take a small amount of your time to tell you those who are on, and more are coming on as we talk, about what we plan today. But first of all, before I do anything else, I think it's important that we make a special note in recognition of the tragedy that happened in Boulder, Colorado this week. Our sympathies and condolences go out to the victims of the tragedy and the police officer who was killed. It's one other instance of why criminal justice is at the top of our agenda across the country. So please join me in a quick moment of mourning and commemoration for those folks who have been lost. This webinar series is made possible by the Academy for Justice at Arizona State University, the Sandra O'Connor College of Law. And we're especially appreciative of the ASU for making this possible. And I wanted to turn this over first to Professor Erik Luna, who's the founder and director of the Academy, to say a few words of welcome, and then we'll move into our business of the day. Erik?
Thank you, Stephen. As mentioned, my name is Erik Luna, and I'm a law professor at ASU Sandra O'Connor College of Law. I'm also the faculty director of the Academy for Justice, which is the law school's criminal justice center. The Academy for Justice is composed of a diverse team of reform-minded scholars and experts from a number of institutions who envision a criminal justice system that incorporates the best practices as determined by fact-based, nonpartisan academic research. Our shared mission is to bridge the gap between academia and on-the-ground criminal justice reform by making research, scholarship, and other ideas accessible to those responsible for designing and implementing our criminal justice system. And this mission is consistent with today's webinar and its hope of enlightening the media's coverage of criminal justice issues. This morning, as Stephen mentioned, I'm honored to introduce our keynote speaker, Chief Justice Robert Brutinel. A graduate of Arizona State University, the University of Arizona, and Duke University, Chief Justice Brutinel was appointed to the Arizona Supreme Court in November of 2010. He was elected as the Vice Chief Justice in January 2018, and a year and a half later, he became the court's Chief Justice. Prior to his appointment, Chief Justice Brutinel served as the presiding judge of the Yavapai County Superior Court, where he presided over cases involving civil, criminal, juvenile, mental health, drug court, probate, and domestic relations matters. Among other things, Chief Justice Brutinel serves on the board of directors of the Conference of Chief Justices, and he is past president of the Arizona Judges Association. In 2010, Chief Justice Brutinel was named Judge of the Year by the National Court Appointed Special Advocates. It is my great pleasure to introduce the Chief Justice of the Arizona Supreme Court, Robert Brutinel. Mr. Chief Justice, the floor is yours.
Professor, thank you for the very kind introduction. It's an honor to be able to speak with all of you this morning. I will confess to being mildly intimidated to talking to a group of journalists. 4 or 5 years ago, I was tasked with chairing a committee to develop rules for use of social media and electronic devices in courthouses in the state of Arizona. I thought I ought to try to understand some of the social media platforms, so I got myself a Twitter account, and I was immediately followed by about 35 people, all of them journalists. And so I have declined to send out anything on it ever since I got it. But I'm looking forward to talking to all of you today. As Professor Luna said, I've been the Chief Justice for about 2 years now. It'll be 2 years in June. And I'll talk a little bit about that, what we do in the process for change in Arizona. But I have to tell you that the last year, like for a lot of people, is not really what I anticipated when I was elected to be the Chief Justice. As a bit of background, and because a lot of you are not from Arizona, let me highlight a few aspects of Arizona's courts. The Arizona Supreme Court has 7 justices, like the courts in Colorado and Nevada. Arizona was a court of 5 justices like Utah until the legislature decided to expand the court in 2017. At the time, we were fairly adamant that we didn't need an expansion of the court, and I can talk at length about why 5 is better than 7 and how we were more efficient before, but not unusually, the legislature had other concerns than what we thought, and they decided to expand the court. And in truth, it's been a good thing. I have very good colleagues. It's a great place to work, and it has been positive for the most part. Arizona, unlike a lot of states, is not a unified court system. So Arizona has separate state and county funding. It has a single Supreme Court. It has a single Court of Appeals that has 2 divisions. One sits in Phoenix, one sits in Tucson, and the cases are divided up geographically. It is managed from the top down. So we have a statewide Superior Court. It's a single Superior Court, but it has 15 counties, one located in each of the counties of the state of Arizona. And each of those counties is managed by a presiding judge, who is appointed by the Supreme Court. Each of those counties has justice courts, limited jurisdiction courts, which are picked by the voters in those counties. In the larger cities and towns have municipal courts, and they're chosen by a variety of means, all of which relate to the city, are chosen by city councils or by elections in the cities. Again, superior courts, including probation, which is a huge part of what we do, is funded in part by the state and in part by the counties, and that creates some interesting issues around funding and who gets raises and how we pay for those things. Arizona has a hybrid system with regard to how we choose judges. So all the appellate judges in Arizona are chosen by merit selection, and that's basically Missouri plan merit selection, a commission on court appointments that sends names to the governor, and those names are then the governor's required to choose from those names in order to make his decision as to who he's going to put on the bench. They did an interesting thing in Arizona, which complicates how this process works. Arizona has an independent redistricting commission, and the people who sit on the independent redistricting commission are chosen, or the names that are sent to the people who choose are chosen by the Commission on Appellate Court Appointments, which makes for some interesting jockeying when they determine who sits on the Commission on Appellate Court Appointments, which I chair. All of the other judges in Arizona, four of them, the Arizona counties choose their trial court judges by merit selection. That is, their Superior Court judges. The rest are chosen along with the justices of the peace by direct election. That seems like a strange system, but it actually works pretty well. People in small counties, there are very few judges and people know who they are. Maricopa County, where Phoenix is, has 98 elected judges, and the thought of 98 judges on the ballot and trying to figure out how that was going to work, the merit selection is a much better option. In addition to taking the money out of these races, and we can talk at length about why that's a positive thing, and why we don't spend $3 million aside to elect justices to the Arizona Supreme Court. The merit selection judges are retained by retention elections. There are not direct elections for those judges. The Superior Court judges sit on a 4-year cycle. Supreme Court justices and Court of Appeals judges sit on a 6-year cycle. For the most part in Arizona, those elections are not particularly controversial. Arizona judges are required to retire at the age of 70, at least the Superior Court and appellate judges are. And judges appear on the nonpartisan section of the ballot. We like to think of ourselves as a leader in justice system reform, and that, I think, has been true for a number of years. So, for instance, Arizona was a leader in jury reform. The idea that we would let jurors ask questions during the trial, which is still anathema in some states, originated in Arizona. We let jurors discuss the case during the trial as long as they're all together in the jury room. We try to make the process a lot more pleasant and informative for juries, and that's been, I think, a tremendous innovation. As a lawyer, I really like letting jurors ask questions because I got an idea as to what they were thinking. Arizona's been a leader in civil justice and discovery rule reform, particularly electronic discovery. We're piloting projects in online dispute resolution. We've been a leader in juvenile dependency reform. Arizona was the second state, I think, was an early adopter, was a model court state to speed up dependency case processing. That is a process to get children out of the foster care system. We are now one of the leaders in what's referred to as the Dependency Alternative Program, and that's an initiative that's going nationally. And the idea is that the court gets involved before a child is taken into the foster care system to see if we can provide resources to parents in order to keep the child from ever getting into that system. Arizona's been a leader in juvenile detention reform, access to justice initiatives. We were the second state behind Utah to adopt rules to allow alternative business arrangements, that is, to let non-lawyers invest in law firms. And we just created what we call the limited paralegal program, or licensed paralegal program, rather, LP, to allow limited practice by non-lawyers in our courts. We are one of a number of states who are trying to work on the sequential intercept model to improve mental health, to train judges to identify mental illness and to get people out of the justice system into appropriate treatment. And we have been a leader in bail reform, which I know is a topic you're going to take up later in your agenda. As part of that drive to try and manage system reform for the last 25 years or so, the Chief Justice has created a 5-year strategic agenda for Arizona's judicial branch. Court leaders who include presiding judges, elected clerks of the court, court administrators, adult and juvenile probation chiefs, tie their projects and day-to-day efforts back to the judicial branch's strategic goals. We found that this statewide approach ensures that our goals, the number one of which is access to justice, another is improving trust and confidence, public trust and confidence in the courts, and other concepts in that agenda are adapted to both rural and urban areas. They meet local needs, but they stay consistent with the overall direction of Arizona's courts. And that really is a statewide effort to try to create a document that the entire court bureaucracy can look at to say, this is the direction that we're going to take. Of course, our focus on both the criminal and the civil side changed with the coming of the pandemic. One of the topics that you guys are going to take up today is how the pandemic has impacted the justice system for better or for worse. And for all of the worse, for the backlogs, for the delays, there have been pandemic prompted innovations, which will remain as part of what everybody now likes to refer to as the new normal. Our view, my view, early on was that our courts had to remain open at some level. People have important constitutional and legal rights which won't wait even for a pandemic. Defendants in custody are deprived of their liberty while they await trial. They can't simply sit in jail while that happens. Families need a resolution regarding custody and visitation matters, and those problems got worse and not better during the pandemic. Battered spouses still need orders of protection against domestic violence, and that won't wait. Children are still being abused and neglected and are in need of protection, and there has to be a process to make that happen, even in the face of a pandemic. Statute of limitations continue to run for filing cases that require cases be filed, and those are statutory matters which the court can't in and of itself extend. So we needed a way to be able to make sure that happened. But at the same time, we needed to keep our employees and the public safe. And we recognize that unlike most businesses, we don't typically give people a choice as to whether or not they come to court. We order them to come to court, and we impose sanctions when they don't. So if we were going to make people come to court, we needed to, A, have as few people as possible come to court, and B, make sure that they felt as safe as we possibly could make them feel. So we mandated masks. We mandated distancing in courthouses. Instead of sitting juries, when we got back to juries, in the jury boxes, we set them in the courtroom, which meant we needed limited access to the courthouse and who got to attend to court proceedings. Initially, we suspended jury trials. We severely limited all types of in-person proceedings, but our clerk's offices remained open and staffed, and judges still held necessary hearings. Judges were going to work, albeit on a somewhat limited basis. We expanded e-filing in both civil and criminal cases and throughout the state of Arizona. We had been actively pursuing e-file, and we had pretty much gotten to an e-file system in civil cases, but we have expanded that to all types of cases, and again, throughout the state of Arizona, including all of the smaller counties. Virtual hearings became the norm for us, and I will tell you there was lots of pushback on that initially. One of our counties, Mojave County, has become kind of a star nationwide because they actually went to virtual grand jury proceedings. That is, they held the grand jurors appeared by video, the witnesses appeared by video, as did the judge and the prosecutor. And at least 2 other states have copied that. I get calls from chief justices regularly saying, can we talk to those people? We'd like to know how they did that. We had tried to expand the use of video appearances, particularly initial appearances in criminal cases. And we got a fair amount of pushback. The judges were not really happy about it. The prosecutors wanted to appear at the courthouse. The defense lawyers didn't like not being able to the courthouse, and they had to go to the jail to appear on the video with their clients. In at least one county, a lawsuit was filed. We got a fair amount of pushback. And then a fascinating thing happened as a result of the pandemic. One of the things that we saw was that jails really wanted to limit the number of people who were entering the jails. They wanted to reduce their populations as much as they could for obvious reasons, but they also wanted to limit the number of people and thus the vector for infections. So they did something we'd been asking them to do for years. They arranged for virtual attorney visits. So now a lawyer can visit his client by Zoom. He or she can appear at the initial hearing in front of a judge. Everybody is appearing virtually. Nobody is in the same room. And the wonderful thing that happened as a result of that is trial judges now tell me that they no longer get complaints from prisoners that my lawyer never visits me. If you're a practicing lawyer who does criminal work, you know that going to the jail is burdensome. It takes a big chunk out of your day. Jails typically are not very conveniently located. It's not a really pleasant place to go. This has resulted in lawyers being able to get a hold of their clients very readily and a real improvement in the system. Again, I don't think that will ever change. Evictions cases. We have a tremendous number of eviction cases. There's kind of a patchwork of federal law as a result of the CARES Act and the CDC order. We have a backlog of evictions cases. We're still working through. In fact, I just signed up. I will sign an administrative order this week as soon as CDC tells us what they're going to do with the new order with regard to how judges have to handle eviction cases in Arizona. But the usual rule of appearance cases is 80 to 90% of the tenants failed to appear. And we started allowing virtual appearances in eviction cases. And that's now flipped. 80 to 90% of the tenants now appear in those cases, which for me is a huge thing in terms of due process of law. Likely that will never change, at least completely back. I will probably sign in the next month an administrative order allowing a pilot project requiring virtual civil jury trials in at least one Arizona county. And I'll talk in a minute about backlogs, but a huge thing in Arizona is trying to deal with the backlogs, particularly in civil cases. And the big problem is, given that we have to socially distance, trying to find space in order to hold those trials. If we can do them virtually, that means we can bring in retired judges, we can bring in pro tem judges. We don't have to worry about the space needs, and we can do a much better job of trying to address that backlog. Another example of something which really improved with the pandemic is domestic relations orders. Arizona, the legislature mandated that we create an online system for parties to create, file, and process information regarding domestic violence protective orders. So if you were being abused and neglected, you could come to court, you could get an order taking your spouse out of the home, requiring that he have no contact with you. And we created a system which went online January 2020 in order to do all of that virtually. You could do it online, the court would get the documents, you could then come to court, see the judge, get the order, it would be transmitted automatically to the sheriff and served. Obviously, it was a simple step after that to say, well, you don't even have to come to the courthouse. We can do that online. We can hold the hearing online. We can issue the order, and thus you can get the order that you need in order to help you stay safe. So it both promotes physical safety, but it also protects the health of the people who have to come to court during the pandemic. It isn't all entirely positive. I mean, we've traditionally wanted the parties and the other participants in the courtroom, including the media, to be able to directly observe public court proceedings. Obviously, we transitioned mostly to remote appearances and remote observation. When you're doing a virtual hearing, you can't hand a document to someone. You can't have the lawyers approach the bench. You can't even really see someone's lips move. When you can't understand what they're saying, the judges lose nuance, and that's true of oral arguments in appellate courts as well. You lose your ability to observe witnesses to some degree at least. And as I was telling Professor Loon, it's also difficult to get the lawyers to stop talking so you can ask a question when you're trying to do that online. Um, it's hard to get their attention, but we found ways around all of that. So while virtual hearings are not ideal, I will tell you that even the most confirmed dinosaurs, including myself, recognize as a result of this that we can work virtually, and that in certain situations it is preferable to do so and will remain preferable to do so. So we will continue to do this even after the pandemic. An interesting thing I discovered related to emergency orders, of course, in Arizona, as in most states, there's a statutory process which gives the governor broad discretion in the event of a declared emergency. In Arizona, he certainly exercised that discretion, but it turns out there's no such provision for courts. And part of my communication with Professor Luna, he asked me about things that I would change if I could just snap my fingers. And that's a thing that I would change. It turns out that there are numerous statutory provisions which become difficult or impossible to comply with because of the pandemic. A good example is grand juries. Arizona law mandates in Pima and Maricopa County that they hold grand jury proceedings. That became impossible. They were continuing to hold sessions with existing grand juries. The grand jury's terms expired, and so the question was, how do we deal with that? And of course, we try to follow the law. So we wanted to comply with those provisions, but it would have been really good in a whole bunch of different circumstances, like statute of limitations, to have had the authority to say, look, during the period of the declared emergency, we're going to suspend the implementation of certain statutory provisions in order to deal with this problem. Another issue which I just found entertaining was the issue of marriages. Our administrative order said courts can continue to issue marriage licenses. California's did not. And the result of that was, as I started getting phone calls from clerk's offices and courts along the Colorado River, because it turned out a lot of Californians that wanted to get married were crossing the river in order to get their licenses. And it was creating a social distancing problem, and they asked if we could stop issuing licenses to Californians. And I told them we couldn't do that, and we would continue to issue the licenses, and that's how it worked out. We've done a number of other innovative things, juror outreach. We've had counties that actually call each of the individual jurors to ask if they're comfortable coming to the courthouse. We now use jury questionnaires and pre-screen jurors so that people who are not going to be able to serve don't have to come to the courthouse. We've expanded our electronic filing and electronic access to court records. We've expanded our ability to take online payments and off-site payments, and we're now educating people, particularly judges and probation officers, by Zoom. So we're still continuing to do the judicial education we're required to do, but we're doing it online instead of in person. The interesting thing for me, and this particularly applies in the criminal context, is we have a case backlog. It turns out, based on our investigation, that there are not lots of unfiled criminal cases out there that are going to get filed back when things open up a little bit better, which they are doing in Arizona. But there are lots of cases which have been continued. We liberally granted continuances to people that wanted them. And every trial judge knows that what settles cases, and in Arizona, the vast majority, as it's true throughout the country, the vast majority of cases settle. In Arizona, we try less than 1% of criminal cases and civil cases, and much less than that to the jury. So the vast majority of cases settle, but they don't settle unless a lawyer knows that there's a prospect of an upcoming trial. And that was not a credible threat during 2020. Additionally, we have priorities in which we have to hear the cases. So the idea that we will get back to trying jury cases and again have we credibly can assert to the parties, look, your case is going to get tried, so you need to sit down and think about where you really want this to go. I think will go a long way to resolving those cases. I think I'm running out of time, Professor, but let me touch on the one last issue. One of the casualties of limiting the number of people who can be present in the courtroom for safe distancing was the exclusion of media representatives. We want the media in the courtroom. We want the public in the courtroom. Our pandemic order limited in-person proceedings to the attorneys, parties, victims, witnesses, jurors, and court employees. And it said that presiding Superior Court judges were to provide public access by video. And I recognize that that is not an acceptable alternative. And so on the basis of a complaint filed by some ASU students, we modified that order to provide, as part of that administrative order, that judicial leadership should authorize admission of a media observer or request or a representative of a media pool to in-person proceedings to the extent possible. In other words, we tried to emphasize that one of the things courts have to do is try to make sure that the media has access to these proceedings. And let me just wind it up, since I just saw the chat that said we've only got 15 minutes left, and I do want to leave a lot of time for questions. Again, what you folks do is critical to what we do. As James Madison wrote in the frequently quoted Federalist 78, courts have neither force nor will, but merely judgment. We depend for our ability to do business on the shared idea that we follow the rule of law, and on the public's belief that courts are fair and neutral arbiters of society's disputes. That belief is under regular attack, of course. Decisions are criticized not on the basis of their legal reasoning, but on the basis of the politics of the president or the governor to the point of the judge. And when I see that this judge was appointed by a Democrat president or a Republican governor, my heart sinks just a little bit. We depend on all of you to understand and hopefully convey that one side of the case is always going to lose, and that the judge may have decided against your side because he or she thought that the law required it. I firmly believe that you work hard to get your reporting right. We will work hard to provide you accurate information, to provide timely public records, and to make sure that the public knows what's available and where to get it so they can fact check and confirm on their own. We want to be partners with the media, and I sincerely hope we can see that collaboration continue. And with that, I would throw it open to questions.
Great. Thank you, Mr. Chief Justice. Just a quick reminder to our journalists who are joining us, if you have any questions, please type them in the Q&A box at the bottom of your Zoom page. Mr. Chief Justice, let me begin with a kind of a general question that might prime the pumps. What issues in criminal justice do you believe the media that the media currently does not cover that you believe they should cover? Or kind of the converse, what issues in criminal justice that are in fact covered by the media, which issues do not receive sufficient context, or there's a lack of appreciation of the justice system?
Well, 20 minutes went by a lot quicker than I thought it was going to, and I would have talked a little bit about diversity in the courts and a little bit about juvenile justice and a little bit about the criminal courts with regard to both criminal justice reform and a really interesting topic for me, which is the vanishing jury trial. And we see that both in civil and criminal cases. As I said earlier, we try less than 1% of the cases in the state of Arizona, both civil and criminal. In the criminal side, I would say that the primary reason for that is because we have created a system of statutes which is sufficiently draconian that if you have a multiple offenses, a second offense or a third offense, as a trial judge, I've had conversations with people who say, I don't want you to plead guilty to something you didn't do, and certainly you have a right to go to trial and you should exercise it. But if you get convicted of this, you're going to go to prison for the rest of your life. Whereas they're offering you a deal where you're going to go to prison for 5 years, you really need to think about what's going to happen here. I don't like having that conversation. I think people ought to go to trial when they want to stand up and say, look, I didn't do this. But we have a system that makes that very difficult if you have prior offenses. And we ought to be trying more cases to juries in the state of Arizona and nationally than we do. So I think that's an issue that gets very little attention. I think plea bargaining practice generally is an issue which has not gotten the attention, at least in Arizona, that it deserves. And I just created a task force as part of a racial justice initiative that we have in Arizona. And the idea behind that task force is to examine plea policy to make sure that it's being administered evenly across the 15 counties in Arizona. I saw in some of the comments or in some of the written materials that someone said, I'm sorry, I can't remember her name, that this may be the year for criminal justice reform in Arizona, and it may be. And certainly it's an issue which we would like to be involved in. We don't try to prescribe policy. We're very careful not to tell the legislature what we think they need to do, except to the extent that affects our business. But we are willing participants, and certainly we are willing to provide whatever information we can to get good criminal justice reform in the state of Arizona, which I think is long overdue. So those are some of the issues. Oh, and juvenile justice. You really need to hold us in the system accountable, particularly with regard to child welfare. And Professor,
thank you, Mr. Chief Justice. That's terrific. Let's turn to some questions that we have from our members of the media. This is from Tim Igo, excuse me, Tim, if I got that wrong. He's with Arizona Attorney Magazine. Could you speak to the possible rule changes regarding peremptory challenges in jury selection and the impact that could have on public perception of racial justice?
Sure, and I, of course, know Tim. And there are two petitions before the Supreme Court now, both to address what we refer to as Batson issues. Batson, of course, being the Supreme Court case that said that you couldn't strike jurors on the basis of race, that it was improper to strike jurors on the basis of race. And it creates a process for determining whether that occurred. And to digress just a tiny bit, the administrative order consistently has limited peremptory strikes in the state of Arizona during the period of pandemic, and has completely eliminated peremptory challenges for judges. One of those proposals would modify Batson to create an objective standard as opposed to the subjective standard we currently have, which the state of Washington just did. And the other, which was filed by two Court of Appeals judges, would simply eliminate peremptory challenges. And admittedly, that would solve the problem. So I guess I agree with the premise of the question that if we strike jurors on the basis of their race, that certainly is not race neutral and is in fact racist, and we shouldn't be doing that. And judges should actively work against having that happen. The problem from my perspective is, as a trial lawyer, jury selection is an art. And to try to look into someone's head to say, did I strike them because I thought they'd be a bad juror for my case, as opposed to I don't like the color of their skin, is a very difficult thing to do. I suppose, other things being equal, today I would lean towards, let's just get rid of peremptory challenges. As a lawyer, I would have hated that. But it does solve that problem, and it makes the system more efficient. But we'll see what my colleagues think when it comes time to take up those rules.
Thank you, Mr. Justice. Another question. This is from Felicia Fonseca, who's with the Associated Press. How will the courts determine when it's safe to welcome jury trials back in the courtroom? Is it going to be pursuant to the CDC guidance, or might it be some kind of decision-making by the state judiciary, or might it be something that is decided by other entities in Arizona?
Well, we will decide that. And we'll do it based on the science, and we'll do it based on, and how we do it will be based on CDC recommendations, which is what the current administrative order says. It basically creates a three-phase plan. I will tell you, in Arizona, 14 counties are currently trying jury trials again. They're doing it with appropriate social distancing, and the other counties will start April 1st. So we're already back in the business of jury trials. The administrative office of the courts, which is 400 some employees that work in the building that I'm currently in, will bring employees back full-time April 1st. But we'll kind of do it. We're going to do it gradually, so that we'll start with 3 days a week and then move on. And we've done that because everybody in this building has had the opportunity to get the vaccine. And as that becomes true in all of the courts in Arizona, court employees are coming back to work. One of the things we learned as a result of the pandemic is that there are jobs in which we don't need people in the building to do. And we are taking a hard look at who we actually need to have come to the building. But those decisions will be made for business reasons and not for pandemic reasons. And we will continue to do appropriate distancing as recommended by the CDC and the State Public Health Department in order to keep the people that come to the courthouse safe.
Thank you, Mr. Chief Justice. This is a question from Chandra Whitfield. She says, I know you mentioned wanting the media in the courtroom. Please elaborate as to why you think this is especially critical, what it brings to the table. What do you think has been lost by media being away during COVID?
Courts need to be transparent. And I will tell you that in an effort to continue to be transparent, we have put up data dashboards so that you can look at historical data on a whole variety of issues when you go to our website. I always had a good working relationship with the reporters in my community. And what was important to me is that the public understood what we were doing. And I tell new judges on a regular basis, you need to be out in the community. You need to be telling people, what courts do, how you do your job, so that they understand that what our business is about. Most people don't understand what we do. They don't know where the jails are. They don't know anything about the people that are in the jails. And those are all, I think, critical things for the public to understand. And it used to be we had jury trials as a means of public education. I think the founders did that rather directly. But we don't try very many jury cases, and so we're losing that as public education as well. So we really do depend on you folks, on journalists, to explain to the public what happens in the courthouses, how cases were handled, um, whether resolutions were fair, is the system working the way it's supposed to, and frankly, it keeps us honest. Judges ought to understand that what they do is going to be in the newspaper. It's going to be on for those of us that still read newspapers. It's going to be on the TV and on the internet, um, and govern themselves accordingly. We expect judges to be courteous. We expect them to treat people appropriately, and we want to know when they don't. That's one of the way we find out. So for a lot of different reasons, I think it's critical that we have journalists there. And I think just like a judge watching somebody on TV as opposed to watching from the bench, it's a different experience. And I think you folks lose a lot of nuance as well if you can't be in the courtroom.
Thank you. Here's a question from Jessica Cutts, if I have the name right. She was curious about how virtual hearings have either hindered or helped those who do not speak English.
Well, interesting question. We provide interpreter services for a broad variety of languages, the primary one in Arizona being Spanish. We have lots of, but never enough Spanish interpreters. But one of the ways we can provide those interpreter services is there's a language line for virtually any language. And we can do online interpretation, although that was not anybody's preferred way to do it. But if you have a virtual hearing and a virtual translator, that actually works pretty well. So I think it probably, as people become more accustomed to doing things virtually, it's made for a better experience for everybody doing translation services online.
Terrific. Mr. Chief Justice, this is from my colleague, Hank Fradella. The Arizona Supreme Court led bail reform efforts in the state. Today, courtrooms require the use of the least onerous release conditions that will ensure appearance and protect public safety. But the Fair Justice for All Task Force recommended abolishing cash bail, and that did not occur. And although bail eligibility hearings must occur within 7 days of arrest, a week in jail is a long time for someone, and it has the potential to generate more crimes, what they call being criminogenic. Can you comment on what additional bail reforms, if any, you would like to see occur in the state?
Sure. Great question. And I agree with everything that you just said. This is a political question. I mean, ultimately, to do away with money bail in Arizona is a statutory question, not a court rule question. And we can talk about the politics of that if you want to. We did, as I mentioned earlier, we held a series of roundtables with the Arizona Judicial Council and the Arizona Commission on Minorities, which has been in existence for 30 years now, to talk about things we could do immediately to make a difference with regard to racial justice in our courts. And one of the things that came out of that is exactly what you said, which is people sit in jail too long when they can't meet release conditions. And so what we could do is change our rules, and what we have done is change them to say if you don't get out within 48 hours, the judge is required to give you a lawyer, and consider additional release conditions and give you a hearing on that to see if there's a way to get you out. Because I absolutely agree with the premise of the question, which is if the risk justifies letting you out of jail, losing your family, losing your home, losing your job, losing your car, are all things we don't want to see happen, and we want to get you out of jail if we can safely do that. So we're looking at ways that we can get people out quicker.
This is another question from Tim Igo. What influence do you as chief have on court clerks to make sure all new case filings are available to the press and the public immediately after they are filed without a lengthy processing time? I'd
like to think that they listen to me. I do have some ability to change the rules, and I do govern the rules generally about what happens in clerks' offices. Um, I guess I would want to identify specific problems. I mean, clerks need to be able to do their business. They are independent elected officials. But I do think they share the same desire that we have to be as transparent as possible. So if there's a specific problem, then Tim, you're welcome to contact me offline. I'd certainly be happy to talk about it, and perhaps we can resolve it.
Thank you. This is this is a question from Nikki Roberts. During your keynote address, you mentioned the word safe several times. In your own words, could you define what public safety means to you?
It depends what you're talking about in the context of the pandemic or generally. The ultimate job of a criminal court is public safety. That is, when we make release determinations, when we make sentencing decisions, the first thing we look at is what is required to keep the public safe. We've gotten better about developing scientifically based, experience-based risk assessment tools to try to give us some guidance as to what is safe and what is not, particularly in terms of release conditions. So safe to me in that context is a reasonable belief that a person can be released into the public without the likelihood of him or her committing additional crimes. Safe in terms of the pandemic means, I'm not a public health expert, so I try to follow CDC and State Department of Health Services guidelines. We're in contact with Dr. Chris' office on a regular basis, and we try to generally comply with that. But we also try to do it consistent with being able to maintain the business of the courts. So we didn't shut down completely for the reasons I talked about.
Thank you. Here's a question from Jeremy Duda. How has the expansion of the Arizona Supreme Court from 5 justices to 7, how has that changed things? Have there been any benefits or drawbacks?
I would swear Jeremy's asked me that question before, but I'm happy to answer it. The assertion was we don't see enough dissents, and I never understood that one. We do have more dissents, however. That's certainly true. There was some spoken desire to make us more efficient, and I would tell you that exactly the opposite has happened, and for obvious reasons if you think about it. And there's now 7 justices. Each of those justices has 2 law clerks. When we decide a case, we got to get 7 people together, and the schedules are more difficult. 7 people have to work up the case with their law clerks. We then have an argument on the case. We decide the case. There's more likelihood of diverging views with more people. And then you have to write an opinion. And the way it works around here is you circulate that opinion to all 7 people and all of their law clerks. So you get, 6 justices weigh in with edits, and we edit everything. I mean, it's grammar's fair game, punctuation's fair game, certainly the substance is fair game, but also all 12 of their law clerks also weigh in. That all takes time. And in fact, we have gotten more dissents, and dissents take time because you have to wait for somebody to write the dissent once the majority is written, and then you have to respond to the dissent. And the way this works is then we then circulate those opinions, and sometimes an opinion will go through 3 or 4 or 5 iterations before everybody can agree that this is the one we're going to send down. So we have become less efficient in that sense. The positives, however, are we get more points of view. There are more dissents. There is a broader range of intellectual firepower brought to bear on a specific question. And frankly, they're really good people and they're good to work with. So that part has been exceedingly positive. So I think that on the whole, we've made it work.
Terrific. One last question. This is from Felicia Fonseca of the Associated Press. Arizona's prison population has declined 14% since the beginning of the pandemic. From your perspective, what is driving this decrease? Is it fewer charges being filed by authorities? Is it defendants less inclined to accept pleas than send them to prison and perhaps expose them to COVID-19, or perhaps some other cause?
I have no hard numbers on these things, so anything I say is purely anecdotal and speculation. There was a concerted effort, I believe, on the part of the Department of Corrections and jails generally in Arizona to get people out because it's a public health problem. Jails are a great place for contagion, and so they wanted to get as many people out as possible. Criminal filings in Arizona are way, way down. And that originally caused us, as I mentioned earlier, started looking to see if there was a backlog, to see if there were a bunch of cases which the county attorneys had not filed that they would file when they got back into the grand jury business and thought it was appropriate to do that. What we're being told is that's not the case. There simply has not been as much crime. And now, how that translates into when a person actually gets to prison, we'd have to examine the dates. But I think certainly that has had an effect on it. Criminal cases are not getting tried because lawyers. I have heard anecdotally that lawyers are waiting for the administrative order to end so they can file notices of change of judge and get their preemptive challenges back. That may or may not ever happen. But cases are not being resolved as a result of that. So I think a combination of those things has resulted in smaller jail and prison populations.
Thank you. We've come to the end of our time, everyone. On behalf of Arizona State University and Sandra Day O'Connor College of Law and our partners at John Jay, I want to thank Chief Justice Robert Brutinel for joining us today. It's been an honor and a privilege to have you here and share your insights with us and with the media. So thank you for joining us.
Thank you for the opportunity. Have a great day.
You bet. Thank you, Chief Justice. Let me turn it over to Stephen. I think your mute's on, Stephen.
It is, yes. Let me add my thanks as well. We still have a few other questions. I want to thank our participants. They've got a lot of questions. Some of them have not yet been answered. So if the Justice doesn't mind, we will send the unanswered questions over to the Justice for him to answer later. In the meantime, as we prepare for our next session, we'll take a 10-minute break and we'll come back shortly. Thank you all.